Welcome back to the TuckerAllen web and podcast. I'm Scott Trout, your moderator for today, and we continue to bring you information regarding estate planning and elder law and any issue regarding that, and try to kind of break it down in more simple terms as we go along and do these podcasts each week. And today is no different. Today we're going to be talking about personally a myth where we talk about trusts and whether or not trusts are just for wealthy people. They're not. So we'll talk a little bit about that with our guest from TuckerAllen. But before we get started, as I always start my podcast, make sure you understand that this is an attorney-client relationship. We don't want to give you legal advice today either. This is educational, informational. We really want this to be talking points for an opportunity for you to seek out an attorney. Have a consultation, because there is no substitute to that, and certainly this is not one of them. But what this really is to kind of equip you, prepare you, give you the talking points that you need to maximize that consult that you have. And speaking of consults, TuckerAllen has offices in Kansas City and St. Louis and across the river in Illinois. We are available for a consult. If you'd like to reach us, you can find us online at TuckerAllen.com, or you can reach us at 866-335-3375. And you can give us a call. We can do it virtually via Zoom, just like this, or we can do it on the phone or in person, where health and safety, obviously is a priority. And we want to make sure that is an option for you if it is available and you feel it's appropriate. So let's get started today, and let's kind of talk a little bit about trusts and whether or not who needs them and whether or not they're important, and kind of break down some of the intricacies and the definitions. So Kevin Mason joined us from TuckerAllen. Welcome.
Thanks for having me today, Scott. I'd be happy to talk about trusts.
Yeah. So, I always hear, I was talking to someone a couple weeks ago, and just generally talking about trusts. And they said, well, don't I have to have a lot of stuff in order to have a trust? And I was like, well, no, obviously. Before we get to kind of why don't we define what that is? Because it's so, there's a lot of confusion out there. There's, misunderstandings, there's misdirections, there's bad advice. Their neighbor tells them something, they see it online, these cheap forms. So let's just break down, what is a trust first?
Sure. So we'll look to see exactly what the requirements for a trust are. We'll go to the Uniform Trust Code. And now that hasn't been adopted in every state, but it has been adopted in nearly every state, including Kansas, Missouri. Illinois adopted most of the Uniform Trust Code. And so what they kind of give us 5 requirements for what a trust needs. So the first requirement that they give us, and by the way, I'm going to use some terms here like grantor, trustee, beneficiary, and after I kind of get through this requirement list of what a trust is, I'll go back and describe exactly who these are in a trust. So the requirement would be that the grantor must have capacity to create a trust. So what that means is that this person, this grantor, they have to have the mental acuity to understand that they are creating a trust, that's what they want to do. Then the second requirement would be that the grantor must intend to create the trust. So we have to have some sort of verbiage that says, okay, this person, I am here today to create a trust. Then the third requirement would be that there must be at least one definite beneficiary. So at least one person that is getting, or group or organization that's getting some sort of benefit from this trust property. Then the fourth requirement would be that there are duties for the trustee to perform. The fifth requirement would be that the sole trustee cannot be the sole beneficiary. Okay, so now let me describe who these people, the grantors, the beneficiaries, the trustees, who they are. So the grantor is the person who they transfer property into this trust that gets created. So whether that property is physical property, such as real estate, or whether it's your assets, an asset such as a bank account, that it can be any of those things. Or if it's a piece of personal property like your watch or a diamond ring. Those are all different types of property that the grantor, that person who transfers the property into the trust could be. So the second person that I mentioned there, a player, would be the trustee. And so what the trustee is, that's the person that has the legal, they have the legal right to the property that's in the trust. And oftentimes, or most often actually, while you're alive, or while the grantor is alive, they will be the trustee of their trust. So they maintain that legal right to the property that's in the trust. And then the final player that I mentioned there was the beneficiary. And that's just that organized person that's getting the benefit of the trust property. And so one of the things that I mentioned there, one of the requirements is that the sole trustee cannot be the sole beneficiary. And whenever you think about it for a second, that makes a little bit of sense, that if you're the sole person with legal right to this property, and you're also the one the sole benefit of it, then you own the property at that point. There's no trust, there's no passing of property.
And Kevin, the issue comes down to is, people listening to that, and they're intimidated by, as you suggested, as you broke down the definitions, gosh, it's complicated. It sounds lofty. It sounds, difficult. And I guess what we break it down is, and we can talk about a trust versus a will. Many people know what a will is. That's been kind of pounded home. And a lot of people, I think, under the misunderstanding that perhaps when they have items, that a will just takes care of everything. And in some respects it does, but what it doesn't do, right, is the trust is an add-on, kind of, in my mind, a perfect requirement, for someone to adequately prohibit or prevent spending more money when you pass. Because if you don't have the trust, right, the will has to go through probate, perhaps, whether it's a small estate or something different, and incurs more expenses. And I always say, look, the last thing you want to do is take your money that you want to go to your family, your friends, a charity, and give it to a lawyer, right? So maybe we talk a little bit about the trust versus a will, and you can kind of go through those things and talk about how they work together in perfect, I'll say perfect unison, right?
Sure, absolutely. So with a will, if that's the only estate planning device that you have, if you have a will, then what will happen is whenever you pass away is that your family or your beneficiaries or your personal representative, the executor, someone is going to have to take that will and go to probate court. And they're going to have to go through the court process to get all of those assets, the inheritance, distributed to the people that you wish them to be distributed to. And that process it's time consuming. It takes, I think 9 months right now in Missouri is a pretty normal amount of time that it takes to go through the probate process, depending on, and if the size of the estate is larger, it can take much longer. If it's smaller, it can take less time, but it's going to take a while. That's also just a very stressful time for your loved ones to have to be dealing with the court process and dealing with, going to court, dealing with lawyers, dealing with the judge, while they should be, you don't want to put that on your family at that time to have to deal with the probate process, because it's stressful, it's time consuming, and it's just not where the family wants to be. So that's kind of where the trust comes in, and that the trust can avoid the probate process for you. So the transfer from a trust is outside of the probate court process. And since it's outside of the probate court, you don't have to be in court. It's much more efficient way to disperse your assets to your beneficiaries or loved ones after you pass away. And then there's a lot of other pros as well to using a will versus a trust. So the other thing, the big one that a lot of people want is they don't want their loved ones to have to deal with probate. Anybody who's dealt with probate knows that it's sticky, it's time consuming, and it's stressful. It's just not something you really want to do. It's also expensive, which a lot of people don't think about. A lot of times a probate can cost up to 5 to 10 to 15% of the entire estate, whereas a trust, it might be a little bit more money on the front end to get the trust versus the will, but on the back end, you're going to make all that money off.
Yeah, it's like, I always talk about, I use this, maybe it's not a perfect example, but I said, you go get your car washed and you're going to spend some money to get it done. You get half of it. Say, no, I only want you to wash half of my car. Well, if you look at the clean side, it looks great, but then you've got this whole dirty side. But the point is that it's kind of, the clean side's the will, the dirty side's you got kind of the unended, the unperformed, the uncreated trust. They work together. You got to, and I always say, look, the money's worth, and it's a very small investment up front for the peace of mind to ensure the things that where you want to go, the things to happen, go. I was just talking to good friends where they went ahead and did the will and the trust, and naming kind of their preference for where their kids would go if, as they were minors, if they were to pass. And it was peace of mind. And they're like, gosh, we feel so much better when we travel without our kids now. It was worth the money. And they originally came and said, we're just going to go have our will done. And I'm like, look, it's incomplete. You can feel good about it, and someone can make you feel good about just doing a will, but in reality, you got to do the whole thing.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
So that leads to the question, people will, again, we're using these legal terms, and we want to try in this, instance, try to break it down. What is a pour over will? We hear a lot about that. You see it online. What is that?
Sure. So what a pour over will is, that's another legal document, like a trust is, or a will is a legal document. This is a pour over will. And so what it does is it works in conjunction with your trust. So whenever you pass away, it takes what this document says is just that any assets that I have as the grantor that were not placed within my trust during my lifetime, whenever I pass away, that I want them put into the trust. So it's the name pour over came from it's pouring your assets over into your trust that weren't originally put in there for whatever reason. And the reason for this is just that then all your assets again are underneath that one roof for your trustee then to be able to more easily distribute those assets to the beneficiary. And that's another thing that I think people don't always realize with a trust versus a will, is that in a will, it's more rigid. You don't have the flexibility that you get in a trust. In a trust, it's much easier to say, if I had 3 children, for example, and I have a trust, it would be easy for me to say in this trust, I want to split my assets 1/3, 1/3, 1/3 between my children. Whereas in a will, you can say that, but not all of your assets might be covered underneath that will. Anything that's jointly owned wouldn't be covered. Also, you have some issues with, if you have a will and you want to avoid probate still, you can make things TOD, transfer on death. So then maybe you have a brokerage account. So you have an investment account and you want to make that TOD on your death. Well, you want to keep things even between your children, but the problem is that those investments fluctuate every single day, which not all the time people think about. So it can lead to some inequitable inheritances among children. If you make, okay, I'm going to have my bank account that I have $5,000 in my bank account, and I'm going to make that POD to my one child. And then I have an investment account that has about $5,000 in it right now. So I'll make that TOD to my other child. But then whenever I die, my investment account, because I'm not a great investor, so my investment account tanked. So it has $1,000 in it, whereas opposed to my bank account at that time had $6,000 in it. And it just leads to some inequities.
Yeah. We talk about the pour over will. Again, example, these aren't great, but just trying to visualize for people listening, I'm making coffee pot in the morning. I'm going to take it on the go. I'm going to pour it into a go cup with a lid to protect that coffee. Kind of, pouring it into the trust with a lid, and it is protected if done right. You can make sure that all your assets are placed into this trust. They're funded into the trust. There's all kinds of steps to make sure. It's like getting it on the go. You don't want to spill it. You don't want to lose it. You don't want to make it imperfect. You could drink right from the coffee pot, but you're going to spill it all over the place, and inevitably it's going to cost you more money. You got cleaning. Again, a weak example, but trying to let you visualize. That's kind of what the pour over, as you suggested, pouring it into the trust. That's the whole idea. So as we kind of wrap up, let's talk a little bit about something spendthrift clause. You'll find that mentioned, and you'll see it in some of the estate planning documents. What is a spendthrift clause?
So a spendthrift clause is just one of those it's a tool that a trust has that a will doesn't, and it allows for that more narrow estate planning to really get down to exactly what you want to have done. So with a will, whenever you pass away and it goes through probate, then the assets or the inheritance is just automatically distributed to whoever it was to be distributed to. The spendthrift clause, it's just a provision that they're in almost all trusts now. But what it does is it just prevents the trust beneficiary, so whoever that person that is getting the inheritance or the trust assets after you pass away, it just keeps them from using that inheritance to secure credit, to secure future credit. So what that means is that if I someday I have a little bit of money, I have $10,000 that I'm going to give away through my trust to one of my children, but I know that my child, she is not good with money. She likes to buy fancy clothes, and she has credit card debt, and she has a little bit of other debt. And I don't want the creditors to be able to just automatically take that inheritance away from her. So what I can do is I can put a spendthrift provision into my trust, and that just prevents those creditors from attaching to her interest in the trust property. It also makes it to where she can't go into, she wants to buy a fancy car. So she can't go into the car dealership and say, talk to the salesman and let them know that I have a interest in this trust property over here, and I would like to have a loan to buy this fancy car based off of that interest in this trust property. So the spendthrift clause just prohibits all of that and prevents it from occurring.
Yeah. Well, it's good stuff. I mean, whether you're 20s, your 30s, or above, everyone you can utilize estate planning. It doesn't mean you have to be in your 50s or over. I mean, we have plenty of clients that come in their 20s, and, you know, especially if they've had their first child, we're in a pandemic, you know, it's always the point of, you know, if not now, when? You know, we just don't know what's going to happen, the unexpected, and it's better to plan and just have a consultation. Find out, have an estate planning attorney who practices exclusively in that, just like you do. It's important to just hear the information, absorb it, and make a good plan for yourself. So thanks for joining, Kevin. I appreciate the time today.
Yeah, thank you so much, Scott. I appreciate it.
Continue to tune in to our weekly podcast where we'll bring you information like this, just good resources, good tools, good information to break it down into understandable terms like Kevin did today. Again, find us online at TuckerAllen.com, and you can schedule a consultation with one of the TuckerAllen attorneys. Until next time, have a great week.